Good morning, Mr. Cornish.
Morning, Your Honor.
Good morning.
Who's in the jail? Is that Percy Harrison in the jail?
Yes, ma'am.
Okay, Mr. Cornish is taking care of him as well. Got it. Get a report. What do you call that case? We're on the record in the matter of the people of the state of Michigan versus Percy Harrison, file number 22-01722 FY. Council appearance.
Good morning, Your Honor. May it please the court, Steve Cornish on behalf of Mr. Harrison, covering for Mr. Sartz today, attorney of record.
Brian Ring on behalf of the people.
Thank you. Today was the date set for a review on this matter. We adjourned this matter for forensics back in January. We got an update that we were still waiting a bed space. Let's see, is that still the status, Mr. Cornish?
That is my understanding, Your Honor. We contacted the jail this last week when we saw this hearing was coming up. We were informed by administration that they are awaiting a bed at CFP or DHHS, and we are currently just waiting for space for Mr. Harrison to go into. Harrison, sorry.
Okay, sounds good. I'll note that here in the file, and we will set this out another 60 days. We'll set an internal review 30 days out so that we can follow up without having it on the record.
Thank you, Your Honor.
Thank you. Any additional matters on the records on this file?
Nothing on behalf of the people. Thank you, guy.
Nothing from the defense. Thank you, Your Honor.
Thank you, Mr. Harrison. You're all set. Oh, thanks for that file. We're on the record in the matter of the people of the state of Michigan versus John Jacob Kane, file number 23-00238. Council appearances.
Brian Ring on behalf of the people.
Good morning, Your Honor. Again, Assistant Public Defender Steve Cornish on behalf of Mr. Kane, again covering for Mr. Sartz.
Today's the date and time set for a preliminary examination, and then there was a PA 53 contempt arraignment. Okay, and this was a request to adjourn on the preliminary examination.
That's correct, Your Honor. We were scheduled today for both those hearings. We had submitted a stipulation and order requesting to adjourn. My client has had fever, chills. Had fever symptoms, aches, and cough. He has living with somebody currently, as he can't be in his residency. He's been living with somebody who has tested positive for COVID. Rather than appearing in person, we had requested to adjourn this out. I know there was an issue last week that we put on the record. We had submitted something, I believe, to your staff, hoping that the court would agree to that. And we'd also asked the court if it would consider, because of his being evicted. I know there was an issue where he wasn't allowed to go to work for a few weeks due to the tether zone. It overlapped with his employment, so he wasn't able to get paid. He wasn't able to make payments, and they've now evicted him and the AV in this matter from their apartment. And we would have asked if he would be allowed, even with an escort, perhaps, if that would be necessary. Because their stuff's going to be put out on the street, I think, as early as Monday or Tuesday next week. The writ could be issued. They got the 10-day notice thing, is my understanding.
Okay, did you say that he wasn't able to go to work until that's why he got evicted?
Part of it was there was this overlap with the GPS, and he was definitely making payments, but he wasn't able to go to work because of the overlap until we could get in front of the court and get that fixed. Judge Ward did fix that last week so he could go to work again. And now he's back at work and making money again, but he fell behind again on his payments, and now they have officially evicted them, is my understanding.
Okay, I was gonna say, I don't think his eviction had anything to do with his GPS zone. He was just arraigned on this matter on March 9th. And that eviction was likely already pending. He was probably already well behind. He already got a writ date.
I think they were on some sort of payment plan, Your Honor. I don't do the landlord tenant stuff at all. I didn't do that even in private practice, but I believe he was on some sort of payment plan. He missed the payments because he wasn't able to go to work until he could get in front of the court. That has been fixed, but now that is coming up rapidly to where he's going to be removed. So we're trying to get his stuff out of there before the actual writ is executed and they take the stuff to the curb. So that's why I had submitted a stipulation and order request.
I don't see a stipulation order.
You got sent late last night, Your Honor. But the people would stipulate to the fact to allow him to retrieve his stuff with an officer present.
Okay, and then as to the violation, because he's on GPS tether, I think that Judge Ward amended the exclusion zone to be reduced to 1,250 feet, which if the original 2,000 square feet was within his work zone, that his attorney could have made that request on the 9th, 10th, 11th, or 12th to have that amended so that he could go to work. There's no way for the court to have known, and there's no note here from the magistrate that when he was arraigned, he notified her that that exclusion zone fell within his proximity of his job. Also, don't even see where he even attempted to enter into that, and then he was notified that it was within the exclusion zone. So it doesn't even sound like he tried to go to work and that he was violated because of that. That doesn't look like it was an issue. Nonetheless, I do have a violation here alleging that there was more than 21 phone calls in violation of the no contact order. And so there was a no contact order issued on March 9th to you, Mr. Kane, are you there?
Yes, I'm here.
Oh, okay, there was a no contact order, which you were advised of by Magistrate Milmore back on March 9th, says you were not supposed to have contact directly or indirectly with the Anitris Morris. And that included contact by a third party. There's an allegation of jail calls between March 8th and 9th. And the 9th and the 10th, while you were allegedly lodged at Ingham County Jail, that there were multiple phone calls made in violation of the no contact order. So you have the right to have a contested hearing on that. You have the right to have the prosecution put forth evidence to establish beyond reasonable doubt whether or not you violated the terms of your bond. If you are found to be in violation of your bond conditions, your bond can be revoked. You could have to sit in jail pending this underlying case. Do you understand that?
Yes, I do. And I have one other thing to add to your, I notified the public defender's office about
you want to add what?
the, maybe to go back to the exclusion zone. I notified the public defender's office immediately when I seen that it was in the area where it said that I couldn't go with the GPS tether. I have emails to back this up, and was told by the other attorney, Jacob, that there was not going to be a hearing. They couldn't get a hearing, and that I had to wait until the previous hearing to do anything with it. I was out of work because the public defender's office refused to file anything. And I have the email conversations to back that up.
Okay, that'll be noted. I mean, that, I'm glad you noted that on the record. I just wanted to make it clear that the court was never notified of that. So the court could have amended the bond a long time ago.
Yeah, that's what I want to get on record was they were notified many times and tried to get them many times to file something so that I could go back to work. But they didn't do it and forced it to wait until the prior hearing to do anything because they just didn't want to do it because they said that they couldn't get a hearing and probably about 300 other excuses of why they couldn't do it.
Okay, so we'll enter a plea of not guilty on your behalf for the PA 53. We'll set that for a hearing. I do now have the stipulation in order to adjourn the examination. Let's see, due to COVID, doesn't address the 21 days. So, Mr. King, you have the right to have your preliminary examination in this matter within 21 days of your arraignment, and that is what caused it to be set for today. But due to the fact that you have been exposed to COVID and that you're experiencing COVID-like symptoms, I'm gonna find good cause to adjourn because we don't want you to come in the building with COVID symptoms, okay?
Yes, ma'am. That's why I alerted the attorney as soon as possible.
So we'll get you a new date beyond the 21-day timeline. Hold on a second. 27. April 27th. April 27th at 8:30. That'll also be the date of your hearing on the alleged bond violations, okay?
All righty.
Do you have any questions?
Yeah, they're saying something about going to my apartment to get the stuff out for the eviction where I missed the payments, where I wasn't at work and had missed the agreement. I'm not having an officer sit there while I get our stuff out of there. The officer is not going to be happy. They're going to try to rush, and I have to pack an entire 2-bedroom apartment up, and they can't rush it.
Okay,
And as
so
long
this was an address that you resided at with the alleged victim, is that what you're saying?
Yes, all of our stuff
And
is
you
there.
both were evicted?
Yes, we were both evicted
Okay.
because I'd missed the
Mr.
payments
Reed?
because I couldn't go to work.
I'm gonna order that Mr. Ring work with the victim because I agree that an officer doesn't need to sit there while you pack up an apartment. That's not a good use of public
That was
dollars.
my fear. They're looking at a lot of hours, a lot of man hours sitting there doing nothing but,
So
you know,
you need to
twiddling their
work with
thumbs.
your victim so that the victim relieves for a reasonable amount of time so that he can get his stuff.
Will do, Judge.
Okay, and then the attorneys will work together to communicate that time frame to you so you know when you can do that, okay?
Okay, yeah, we have till April 3rd at 4 p.m. to have all of our stuff out, or it's on the curb at 4 o'clock is what they're saying.
We have all that eviction. Do we have that eviction file? What's the address?
5031 or 5831 Richwood Street, apartment 5, 48911.
3rd. April 3rd is Monday. I'm gonna get the hold tight. I need to get the file. I'm gonna have to extend the writ because it's Monday.
Yes, I'd been saying the same thing to the prosecutor's office too, or not the prosecutor, sorry, the public defense office too, and they wouldn't file anything whatsoever to try
Well,
to
they don't
expedite.
handle-
it
They
because of
don't
this.
handle evictions over there, so I can understand why they probably didn't want to touch that. But we can get it taken care of now, sir.
Okay, yeah, no, it wouldn't even get them to touch the eviction. It was to get them to file for your court so that I could get in there and start packing. Not anything to do with having them go to an eviction court. It was for them to come into your court and say, hey, here's their eviction. It's April 3rd at 4 p.m. And I've been diligently on this, trying to get them to file anything to expedite a hearing with.
You know, I'm not going to sit here and just get thrown on the bus, Judge. I asked him specifically to send me a copy of this writ. He didn't do it. I said I'd file something as soon as he gave it to me, and I never got it. And quite frankly, I don't need to sit here and have him bad mouthing one of my attorneys who's been answering his emails and corresponding him for a week and then copying me on them. It is what it is. We don't do landlord tenant work, and I explained
We'll
that.
get it
to you
taken
numerous
care of.
times.
I'm getting the file brought up now. We'll go off the record while I get that file. Let's see. Morgan. We did Harrison already. Someone else supposed to be in jail. That looks like Mr. Harrison still. Is that Mr. Harrison?
Yes, ma'am.
Okay, we'll call the jail and tell them they need to come and get you out of the room, okay?
What's going on?
We're gonna call the jail so that they can remove you from that meeting room, okay?
Thank you.
No problem. They never put, no, Patterson should be here, that's why. Okay. Mr. Austin, you're here with Alan? Yes.
Yes.
Is he here?
I am on the island.
Oh, Lyle Allen's not here?
I don't see him yet, Your Honor. I thought, was it set for this afternoon?
It's 8:30.
Okay. I did,
You can come up.
I did speak with him yesterday, Your Honor. I will need to place something on the record on that.
Okay, sounds good. Okay. We can proceed. We're back on the record in the matter of John Kane. I'm first going to address the fact, Mr. Kane, your lack of, or your eviction has nothing to do with this case. You were supposed to make payment by February. And the affidavit of non-compliance said you made 0 payments. And that was before you were even arraigned and there were any bond conditions. So your bond conditions did not prevent you from paying your rent, sir. That's number one. Number two, I did get Judge Flores, who is overseeing the eviction file, to extend the writ till April 13th so that the prosecutor and the public defender's office can make arrangements so that you can go in there, pack up your things and get them out without the protective party being there. Okay?
Yes, okay. Have a problem with my phone.
No problem. Do you have any questions at this time about that?
So I'm able to, when will I be able to go and retrieve everything out of the apartment that's gotta be packed up?
Okay, well, consistent with my last statement was that the prosecutor's office and the public defender's office will work out a timeline and they'll notify you as to when you can safely go in there to do that without having the protected party in that space, okay?
Okay.
Mr. Rang, you can just direct the emails to me and I will oversee it and keep in touch with Mr. Kane myself, since Mr. Sartz is unavailable currently.
Sounds good.
Any
And
additional
I check my
matters for the
email
record?
all weekend. Oh, sorry, Judge.
Nothing on the people.
Nothing from the
Thank
defense.
you. Thank you.
Thank you,
You're
Your
all
Honor.
set, Mr. Kane. We'll see you on April 27th.
Okay.
Mr. Rigola, can you let Ms. Brittany know that Judge Flores has extended that writ so they can notify the landlord? Okay, did you lose Mr. Austin? We did.
Am I to sign out of this?
That's fine. Game, Mr. Piper.
See? Brings tidings of joy.
I'm sure.
Very rarely.
Okay. Mr. Carter is here, and so is Tiffany Wiggins.
Request for an adjournment, Judge.
Yeah, it says here we're gonna treat it as a PCC.
Mr. Carter's been in trial all week. Chance to go sit down with his client.
Okay, we're on the record in the matter of the people of the state of Michigan versus Tiffany Wiggins, file number 23-00022, council appearance.
Brian Ring on behalf of the people.
May it please the court, David B. Carter Jr. on behalf of Tiffany Wiggins, who is present through the Zoom app.
Okay, Ms. Wiggins, how are you?
Good, how are you?
I'm doing well, thank you. First, let me sign this substitution of attorney. That was just stuck in the file without my signature. And then today was the date and the time that was set for preliminary examination. I have just signed a substitution of attorney for Mr. Carter, but there was a note here. There was actually a note here from Judge Ward that the defendant already waived her 21 days, correct?
That is correct. We did that last week because I was first assigned to it last week. I think the day of the hearing or the night before.
Sounds good. So we just need a new preliminary examination date. We don't need a new PCC date, correct?
That'll be fine.
Either or, Your Honor. I believe this case will be resolved at this level, but to keep the case moving, if you want to set it for a PCC and a prelim, that's okay with me, or just one. It's up. I'll leave it to the court's discretion.
We'll do a preliminary examination. Do April 27th at 9. April 27th at 9:30 work?
I believe, let's see, April 27th. I will be in a homicide trial that starts on the 21st. And that surely will run the whole week of April 24th. And that's in front of Judge Aquilina, and it's the #1 case. It's not one of those cases that may or may not go.
We'll reset it. May 19th, 8:30. May 19th.
I will make that work, Your Honor, if in fact we can resolve the case.
Our May 19th should have been blocked. We have a conference. Oh, not gonna be blocked because of what's his name? Judge Jordan. Yeah, but we shouldn't reset it to that. He's gonna have to do the things that are automatically set for that thing. We shouldn't reset anything. He's trying to handle everybody. I didn't sign that because they didn't address the 21 days. Can you just put it in the file? May 25th at 8:30.
Thank you, Your Honor.
No problem. Any additional matters for the record today?
Nothing bad, people. Thank you, Your Honor.
Nothing for the defense. Nothing for the defense. Thank you, Your Honor.
Thank you, Ms. Wiggins. Did you have any questions?
No, ma'am.
Okay, you're all set. We'll see you on May 25th.
Thank you.
No problem.
Is there a Christian more?
All right, who's this in the jail?
It might be Patrick Wilson. I think the two, it looks like to me. He didn't respond the last.
Mr. Wilson, are we not responding today?
I am.
Okay. Mr. Abbott is representing him?
Yes.
Okay, we'll wait for your attorney before we go on the record with your case, okay, sir?
Yes, ma'am.
Let's see, Mr. Etheridge.
Your Honor, we're ready.
Okay. We're on the record in the matter of the people of the state of Michigan versus Akia Car, file number 22-03526. Appearance for the record.
Good morning, Your Honor. Attorney Derek Edwards, Office of the Public Defender, on behalf of Ms. Carr. Ms. Carr is standing to my left, and she's putting on the hearing assistant device at this time.
Ms. Carr, can you hear me? What channel?
Can you hear now? Your Honor, she advises she can hear now with the device.
Okay, very good. Today's the date and time that was set for a sentencing. I do have a pre-sentence report and recommendation. Mr. Etheridge, did you get a copy of that?
Yes, I did, Your Honor, and I did have the opportunity to review it with Ms. Carr. She advised me she had no additions, deletions, or corrections to the report. She does deny the, on the cover, first page, the next to last paragraph, the full paragraph, she denies that she gave any impression or would like to clarify, she hopes she didn't give any impression that she doesn't know and recognize she has a heroin addiction. That seemed to say that she wasn't being truthful or kind of contradictory when answering questions about that.
Oh, Sounds good. That'll be noted. Any additional changes or deletions?
No, Your Honor, there was some that she asked me to make. Regarding allocution, Your Honor?
Yes.
Your Honor, I would ask the court to follow the recommendation that's set forth. I'd ask the court to consider it, waive any fines, fees, or costs the court can. I guess there are a couple modifications to the recommendation I'd ask the court to consider. She is indigent and is on SSD, and I believe is applying for Section 8 if she hasn't gotten it yet. One of the conditions or recommendations was that she obtain employment. She cannot be employed because she gets disability, so I'd ask the court not to order that. Your Honor, she readily admits she has a addiction to heroin. She advised me the day that she will be going to Glass House on Monday and will be there for 90 days, and that's part of her CPS case. She's advised me that she wants to make the life changes to beat her addiction. She is in the process of trying to get her children back. She wants to make these changes not only for herself, but obviously in order to get her children back from CPS. I would ask the court to not duplicate any services over the term of probation that she's already doing for child protective services. And she advised me she would sign any releases for probation, get the information from child protective services to show what she's doing and that she's compliant. She would ask the court to grant the 7411. And she would leave the term of probation up to the court, taking into consideration the arguments and the fact that she's already getting services through child protective services. Thank you, Your Honor.
So she's going to go to Glass House for how long?
She advised me she'll be going for 90 days, and she is scheduled to go into the Glass House on Monday.
And then how long is she gonna be on supervision for the CPS matter?
Now, I don't know if there is a specific time frame. Did they give you any idea of how long your services are going to last before you get your children back?
They said it's up to me, like, it could be up to 3 months. So whatever I work on.
Oh. Any additional allocution?
I don't. Do you have anything you'd like to say to the court?
No, ma'am.
Okay, I've had an opportunity to review the pre-sentence report and the recommendation as well as the defendant's prior criminal history. The overall scoring indicates, ma'am, that you had a moderate high risk in the category, and that your scores were elevated for employment and family relationships. I think that's pretty obvious based on the situation that you're in with child protective services. But then also you were pretty high or elevated in the substance abuse domain and responsivity domain. I don't think that you've had any other convictions relative to the substance, but it looks like you had some inconsistency or inconsistent use history. That was noted during the evaluation, and so the impression was that you would benefit from some outpatient substance abuse treatment. Noted only that you were attending parenting classes, but you're going to, what services are you going to be receiving at Glass House?
Yes, I finished some of my Crystal Ray classes, but they said that I just have to resume after I get back from the Glass House.
What classes are you going to take at Glass House? Do you know?
I'm not for sure yet, but they said they'll take me places, like to my appointments and stuff.
Okay.
That will be addressing your substance abuse issues.
I think so. I've never been there before.
Okay. All right, well, we'll have to investigate that further. I think the recommendation of the probation department is accurate. I think you need or would benefit both in this and in your efforts to get your children from a term of supervision. I don't want to duplicate any efforts, so I'll make sure that you get with probation so they can get a release and get whatever information you have going on at CPS so that they don't have you doing anything there that you're already taking care of, or anything here that you would already be taking care of there. I'm going to order a term of 12 months probation. While on probation, you're not to use, purchase, or possess any alcohol, marijuana, or controlled substance unless you have a valid prescription, okay?
Yes.
You're required to submit to random preliminary breath tests and or your analysis testing as directed by probation, and you need to pay the fee for that, okay? Not to be at any bars or any nightclubs. You're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm or any other dangerous weapon. I'm going to order that you participate in outpatient substance abuse treatment. If that's going to be addressed while you're at Glass House, that will satisfy this, okay? I will grant 7411 status. Do you have any questions about probation so far?
No, ma'am.
There's a $30 per month oversight fee that you're responsible for while serving a term of probation. $75 crime victim rights fee that per statute must be assessed. Plus a $50 state minimum cost. I'm going to waive discretionary fines and costs due to your indigency. Total of $485, and you'll make monthly payments on that, okay? Do you have any questions about fines and costs? Provide her with advice and rights as to probation so she can review it. If you have any questions after you review it, you can let me know. Mr. Austin wants to go on the record for this one. Thank you. And there's no questions about this, ma'am?
No, ma'am.
Okay. Any additional matters for the record today, council?
No, Your Honor, thank you.
Thank you, and good luck to you, ma'am, okay? Mr. Austin. On the record in the matter, the people of the state of Michigan versus Lyle Mitchell Allen, file number 23-00156. Council appearance.
Thank you, Your Honor. Good morning, Jared Austin, appearing on behalf of and in the absence of Lyle Allen.
Thank you. Today was the date that was set for sentencing, and I do not believe your client is here, correct?
I believe that is correct, Your Honor.
My understanding is you wanted to go on the record to address something on this.
That is correct, Your Honor. I did have contact with Mr. Allen. I spoke to him a couple times yesterday on the phone late in the afternoon. Couple of things, Your Honor. One, he requested that I make an adjournment request for his sentencing hearing today of approximately a week or so. When I spoke with Mr. Allen, I spoke with him a couple times. He did not sound well. He told me that he was not well. Only at one point he called medical services yesterday. I've not been able to independently verify that. But certainly in my conversation, Your Honor, with Mr. Allen, did sound in some type of distress. So I would just ask the court would grant him a brief adjournment. He asked me to ask for a few days up to a week. I would ask the court to consider it.
So we don't know if he's in the hospital or that he's receiving any medical attention. We just know that he didn't sound well.
That is correct, Your Honor. And he stated that he was in the hospital. He was out of the hospital, that he called the ambulance for himself yesterday that came and saw him, left. Did not sound like he was taken to the hospital yesterday, but I guess my concern, Your Honor, would be more geared towards, it sounded like to me, Mr. Allen was maybe having more of some type of mental health crisis than anything. Quite frankly, Your Honor, if he had appeared here today, I would have some concerns if he was appearing that way today, he would be competent to be sentenced.
Concern I have is, this is a situation where he pled to a use of meth. It's not his first time failing to appear, but I think I gave him some leniency last time he failed to appear. And then I ordered him to report to our probation department so that they can provide the court with the pre-sentence report, and he failed to do that. And so I don't dispute that he probably didn't sound well, but I also think he's on meth. So I'm going to issue a bench warrant in order he's remanded to the custody of the jail so that I can address this case.
And I make just an additional record briefly, if I may. Your Honor. My understanding was, Your Honor, he did report to the probation department, I think immediately after he did his plea and did the initial basic information intake. He failed to appear subsequently after that to do a more in-depth interview. I think I discovered the reason why from looking in the notes in our other file with Mr. Allen, Your Honor. It appeared that his contact information changed. I know I had to call him with a different phone number, and he may very well have collected to update his contact information with the probation department, which would likely explain why their attempts to reach him after that were unsuccessful.
What phone number do you have for him?
Pull it up, Your Honor, but it's an 883 number. I know it's 517-883.
We have that. That's the number you put on this questionnaire.
Okay. Well, I know he's called me from a couple different numbers, Your Honor.
Well, he was advised that he needed to, that he had an appointment
Yes.
with the probation department. It wasn't a matter where he's confused that because he reported within 3 days that he was all set. He was notified and given notice that he had an interview set for the 7th of February at 3 p.m. He was also provided the Zoom information so that he could log in for that. So he didn't even have to appear in person for that. And the officer tried to reschedule with him multiple times, and he's not taking care of that. And if he can talk to you on the phone, he can log in for his court dates, and he can log in for his appointment with probation, but he's not doing that, or he's not done that, which is not a good indication that he would be a good candidate for probation if that was something that was recommended anyways. So with that being stated, I'll note that here on the record, but a bench warrant is going to be issued. No problem. Any additional matters on this Friday?
I think further back this round. Thank you.
Okay. Patrice Jackson, that's your matter as well.
Correct, Your Honor.
Had communication with Patrice Jackson.
I have not, Your Honor.
Or issue a warrant, a bench warrant on that one as well. We have you, or you have Williams, but we are gonna run that, correct?
Unclear at this point, but it doesn't appear whatever happens. we're going to be-
Sounds good. Thank you.
I also have Patterson. I also have. Morgan is on.
Oh, yeah, Mr. Morgan, you do. Okay.
Point of clarification, Your Honor, on Ms. Jackson, is that an immediate bench warrant or 48-hour hold?
It's immediate.
Thank you.
Okay, we're on the record in the matter of the people of the state of Michigan versus Ronald Morgan. File number is 23-00762 FY. Council appearance.
Brian Ring on behalf of the people.
Morning, Your Honor. Jared Austin appearing on behalf of Mr. Ronald Morgan. He appears with us today remotely on Zoom.
Mr. Morgan, can you hear us? You're muted, sir. Oh,
Yes, ma'am.
thank you. Today's the date and time set for a preliminary examination. I do have a note here that we were going to treat this as another probable cause conference because your application for court-appointed counsel was still pending last week. So it looks like we now have court-appointed counsel. We just need to address the timeline.
Yes, that is correct, Your Honor. Mr. Morgan, there was some type of issue with the process. I'm not sure what, but we got appointed less than a week prior to this date. I have spoken to Mr. Morgan. I do have the discovery now. I would just ask the matter be reset for the preliminary examination so that I can have an adequate amount of time to go over that with Mr. Morgan. We can determine how we wish to proceed at that.
Sounds good. So, Mr. Morgan, for your information, you have the right to have a preliminary examination within 21 days of your arraignment. And so your examination was scheduled for today. However, because of the lag between the time you were arraigned and the time that you were appointed counsel, the court's going to find good cause to adjourn beyond that 21 days and give you a new date so that you can have your examination, okay?
Yes, ma'am.
Do you have any questions, sir?
No, ma'am.
April 27th at 9:30 is your new date, okay? You need to appear in person, okay, sir?
Yes, ma'am.
Bond was set at 15,000, 10%. That will continue. Any additional matters for the record?
Nothing on behalf of the people. Thank you, Your Honor.
Nothing further on behalf of Mr. Morgan, Your Honor. Thank you.
Thank you, Mr. Morgan. We'll see you on April 27th
9:30.
at 9:30, correct?
Okay.
Joshua Walker?
Yeah, he's out.
You can come in. On the record in the matter of the people of the state of Michigan versus Joshua Darrell Walker. File number 22-03202 FY, council appearance.
Yes, good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Matthew Samuels on behalf of the defendant, Josh Walker, who was present standing by. Right.
Thank you, Mr. Walker. You can keep your coat on. You won't be here long. Today's the date and time set for preliminary examination. I have a Nolly cross, which is essentially a motion to dismiss without prejudice. The necessary witnesses have failed to appear, and the people are objecting to the obstruction of the arrest records under Michigan Compile Law 764.26A. Do you understand that, sir?
Yes, Your Honor.
You understand that without prejudice means that they can reissue this charge against you at a later time?
Yes, Your Honor.
Okay, and that you would have to postpone it or be rearranged, and post a new bond, you understand that?
Yes, Your Honor.
Do you have any questions at this time?
No, Your Honor. The only thing I'd like to address is Mr. Walker is wearing a tether.
He's gotta go and get it removed. He's gotta go back out to the county. And you need to give us about 72 hours to remove any no contacts from the lien, okay?
Yes, yes, Your
Before you go into any special zones that you were previously told not to go into. Do you have any other questions or anything else you want to address?
Honor. No, Your Honor.
Okay, we'll get you a copy of the Denali and then you'll be all set, okay?
Thank you. Thank
Thank you.
you. Thank you, Your Honor.
Thank you. Williams. Let's see. Maybe that's it. No? That's Mr. Green.
I didn't get anything from them via email either. So,
Mr. Green, where was Mr. Green? Yes, trial. His client's not here either?
I know, but probably told them that you.
I'm sure.
Yeah.
Where's the file? That's James. I got it.
Yeah, I saw.
Yeah, someone's got the email and we didn't get the step, so I'm just gonna, I found the cause because he's in trial. John Rico Braxton. We're on the record in the matter of the people of the state of Michigan versus Del Rico Braxton. File number is 23-00384. Council appearance.
Brian Ring on behalf of the people. Your Honor, Dale Coltrider on behalf of Braxton, who's standing immediately. All right.
Okay, today was the date that we set for preliminary examination. Are we ready to proceed?
Your Honor, at this time, I believe there's going to be a waiver up to circuit court. The people at this time are unconditionally waiving their right to preliminary examination.
Correct, Your Honor, we would waive ours.
Okay. Was there an offer?
There is an offer to be placed on the record, Your Honor, and that was to dismiss count 3.
Okay, and Mr. Braxton, how are you?
I'm fine. How about yourself, Your Honor?
I'm doing pretty good, thank you. Today was the date set for preliminary examination, and you have the right to have that examination. You have the right to have the prosecution put forth evidence today to establish whether or not they have sufficient evidence as to probable cause that a crime was committed, and sufficient evidence to probable cause that you are the defendant that committed the crime. Do you understand that?
Yes, I do.
And do you wish to waive that examination today? You understand that the waiver is unconditional? Anybody making any promises to you to get you to waive your exam?
No.
Are any threats being made to you for you to waive your examination? Or you're waiving it freely and voluntarily?
I know. Brian Ten's, you know.
Your bind over date is April 12th. You do not need to appear in court on that date, okay, sir?
Yes, Your Honor.
That's the date that the circuit court will get the file from this court. Your next court date will be in circuit court, but it'll be a pre-trial. And you and your attorney will be made aware of that date, okay?
Yes, Your Honor.
You have any questions so far?
No, ma'am.
Bond was set at $5,000 personal recognizance that will continue. Any additional matters for the record?
Nothing about people. Thank you, Your Honor. No, Your Honor.
You're all set. Thank you.
Thank you. Thank you for your time.
No problem. Thank you. Okay, who is on Mr. Wilson? I'm not seeing Mr. Abbott today.
I've seen him running around here somewhere. I'm gonna go check on the holiday.
Mr. Abbott needs to come, he needs to make his way here. He's got people waiting. And then Williams,
That's Mr. Pfeiffer to Mr. Austin's.
okay, Patterson,
That is also Mr. Austin's.
what are we doing?
Well, we're gonna run with Patterson.
Okay, well, let's get this party started then, because I don't know where Mr. Abbott is. And I don't know what Mr. Pfeiffer's gonna do at Williams, but my note said it's gonna run. Somebody told me otherwise. Can we see if we can get Mr. Abbott down here really quickly? Mr. Wilson, can you wave your hands or stand up so that the lights come back on? Thank you.
Welcome.
What time is this matter scheduled for judgment? What time is it scheduled for judgment?
First room's closed and the lights are off in there. I know she was appearing by Zoom today to do this because she was sick. When I went by earlier, the lights were off and we was in.
What time is his matter scheduled for judgment?
8:30 and
Because I'm gonna start this exam on Patterson. Immediately. I don't know when he wants to go on the record for. Wilson. Mr. Abbott.
Morning, Your Honor. I apologize for my tardiness.
No worries. I understood you were handling some other matters. I just wasn't sure why we needed to go on the record for Mr. Wilson, and I was gonna start an exam. And I didn't want him to have to sit there while we did the exam.
Thank you, Your Honor.
Okay, we're on the record in the matter of the people of the state of Michigan versus Patrick Wilson in file number 23-00552. Council appearance.
Brian Ring on behalf of people.
Good morning, Your Honor. John Abbott representing Mr. Wilson today for this PCC.
Okay, today was the date and the time set for a probable cause conference. Looks like on March 10th, I found the cause to adjourn because the defendant requested a court-appointed counsel. How are we proceeding?
Your Honor, I met with Mr. Wilson and he's made a good point with me, Your Honor, that this is, we're 43 days in from his arraignment. To my understanding, although I just recently got the case, the history of the case is that the first two hearings, he remained silent. He didn't speak. Is that what the court?
That's accurate.
Okay. So, and then you asked me to do an interview with him for a public defender, and geez, they appointed the case to me. So it's been 43 days since he was arraigned, and the basis for the delay is his choosing to remain silent. And I don't think that, and certainly the moment he had contact with the police on the 18th, they advised him that he had a right to remain silent.
Correct.
He did exercise that right to remain silent.
Correct.
And now the 21-day period from that arraignment has expired, and we're more than double that number of days. I'm asking the court to dismiss the case without prejudice under People v. Wesley, since the timeliness of the preliminary exam. It's going to be another 7 days or 6 days, so it's going to be 50 days since his arraignment or so. I'm asking the court for a dismissal here since he hasn't waived his right to a preliminary exam within 21 days. And he is the only. Pardon?
Oh, he did. He did that when he came to his probable cause conference on the 3rd, and he elected to stand mute, which he had the right to do that. So we proceeded to his exam date, March 10th. He on March 10th decided he didn't want to waive his right to silence anymore. He wants an attorney. That's when I found good cause to adjourn. That was the original date, March 10th of his exam.
Right.
He waived it on the 21st day.
All right. Just raising that objection.
Yeah, well, the objection is overruled. He decided on the date of his exam that he no longer wanted to be silent. He wants an attorney now.
Okay.
So I had no choice but to find good cause to get him an attorney.
All right. Thank you, Your Honor. We'll be ready to go for the preliminary exam next week.
Sounds good. I don't know that we'll be ready next week. We won't be ready next week because we are all booked up for next week, but we can get you a new date.
Thank you.
May 25th at 8:30. May 25th at 8:30. Do we need to address bond for any reason at this time?
Your Honor, he's been in jail for 43 days. Ask the court to consider releasing him on personal recognizance. It's a reliable place to stay. The risk department community can be reduced by court order. Thank you.
Okay, he did not provide an address or phone at the time of his arraignment.
1615 South Pennsylvania. Mr. Wilson, is that still a good address?
Excuse me?
1615 South Pennsylvania is still a good address for you?
Yes, it is.
Is there a phone number?
No.
Okay. Mr. Wilson has been in custody of the jail since the time of his arraignment. I don't have any record or indication that he's attempted to make a violation of his no contact order. Is that correct?
I'm running a quick search right now, Judge. As far as I'm aware, as of right now, there are none, Judge.
Okay, sounds good. I think that the original bond does state here that GPS tether with victim notification was ordered. I'll amend the bond to $10,000 personal recognizance with GPS. I won't require victim notification at this time. And if he needs to apply for assistance to pay for the GPS, you can help him online to get that taken care of.
Thank you, Your Honor.
Mr. Wilson, you're not to be within 1,500 feet of wherever Sarah Nichols is, okay?
Yes, ma'am.
You're not to have contact directly or indirectly with Sarah Nichols. I don't think that'll be a problem for you because it looks like you've been compliant. Okay, sir?
Yes, ma'am.
Do you have any questions about your bond conditions?
No, ma'am, I understand.
Okay. Any additional matters for the record, counsel?
Nothing on behalf of people. Thank you, Your Honor.
Not from the defense. Thank you, Your Honor.
Thank you. You're all set, sir. We'll see you on May 25th.
Thank you.
You're welcome. That was good. You ready on Patterson?
I am, Your Honor.
Just have about 15 seconds to chat with him. I think.
No, take your time. Mr. Wilson, you're free to go.
Okay, thank you.
Thank you.
Yeah.
On the record, who is this actually?
Mr. Williams.
Okay.
There's two cases here.
On the record, in the matter of the people of the state of Michigan versus Christopher Williams, file number 23-00235 and 23-00758. Appearance, please.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Morning, Your Honor. Jared Austin, appearing on behalf of Mr. Williams, who stands present on my right.
Your Honor, today is the date set for the preliminary examination in each of these files. The people are requesting an adjournment in the matter due to a clerical error that happened in our office where, to be frank, no subpoenas were generated or run for either of these cases today. I don't know why. I discovered that issue about 2 o'clock yesterday. Immediately tried to get people here. I spoke with the victim. She was trying to get childcare, but she was unable to get out of work for today with less than a day's notice or get childcare for somebody to watch her child. She's still very much on board, would like to come and testify. Spoke to her about 15 minutes ago to confirm that. But because of that error, she was unable to be here. The people were able to get Officer Hale, who drove out here from Grand Rapids, but at that point I had spoken with Mr. Austin, who had agreed that it would be better to simply adjourn the matter to a new date as opposed to starting and stopping it. He gave me permission to allow the officer to leave, which point I did so she could start her drive back to Grand Rapids, especially because I believe she's working the night shift tonight. So as a result of that, I'd ask for an adjournment in each of these matters and for a new date.
Ms. Johnson, that's accurate.
That is accurate, Your Honor, and I believe timeline has already been waived. I think it's at least one of the matters. The new case, maybe not, but I am in agreement with that, Your Honor. I've spoken with Mr. Williams about that, the various options. I could really push the issue and ask for a dismissal, but all that really does is it's going to immediately start the process over again, which really isn't his best interest. So we are agreeing to adjourn both of the matters out.
Sounds good. Okay, so the timeline was waived on file number ending in 235. As to file number ending in 758, today was the original date of the preliminary examination, and due to the clerical error and the lack of subpoenas, the court will find good cause to adjourn. Again, even if your attorney had made a motion to dismiss, it would have been without prejudice. If I had granted it, you'd have to repost bond, because I can guarantee you before you got home, you probably would have this reissued. And then we don't know what your bond would be the next time, because it depends on how the judge views the case at the time of their arraignment. So it's in your best interest, I think, and in the interest of judicial economy, to continue both to a new date and time. You need a couple weeks for subpoena.
2 weeks.
Same day. Oh, looks like we're all booked up. May 25th at 9.
Yeah, I still don't know what caused this. I'm finding out though.
Okay. Do you have any questions, sir? Any additional matters for the record, counsel?
There you go.
Nothing further on behalf of Mr. Williams this time, Your Honor.
Thank you. We'll get you a copy of your notice to appear, okay?
Thank you.
We're on the record in the matter of the people of the state of Michigan versus Scott Thomas Patterson, file number 23-00785 FY. Appearance, please.
Brian Ring on behalf of the people.
Good morning, Your Honor. Jared Osmond appearing on behalf of Mr. Patterson. He is present to my right at council table.
How are you, Mr. Patterson? Okay, today's the date and the time that was set for a preliminary examination. Are we ready to proceed?
People are ready to proceed at this time, Your Honor.
As are we.
Okay, any preliminary matters?
Not from the people, Your Honor.
No preliminary matters on behalf of Mr. Patterson, Your Honor. Thank you.
Thank you.
I just want to confirm, I believe people are only calling one witness and therefore sequestration would not be necessary.
There is an officer here, but I'm undetermined at this time if I need the officer.
Given that, Your Honor, I would just ask for an order of sequestration since there's a possibility of multiple witnesses.
Okay, sequestration order is granted. You can call your first witness.
At this time, the people will call Bethany Burtis.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes.
Think you can have a seat there, ma'am? There's a microphone that's in front of you, and I have a court reporter behind you. She has to take down everything that's being stated here today. So your responses need to be verbal, they need to be loud and clear. Also taking into consideration that we have that glass, so it may block some of the sound, okay?
Absolutely.
Very good, very good. And then if there's an objection from either of the attorneys, you'll stop speaking. I'll make a ruling on that objection, and then I will let you know if you can get that response or not, okay?
Okay.
If you don't understand a question, you can ask to have it repeated if you didn't hear it. And then state your first and last name and spell both of them.
Bethany Burtis, Bethany, BERD as in Diane, ES as in Samuel.
Proceed, counsel.
Thank you, Your Honor. How are you today, Ms. Burtis?
Very good, thank you, it's Friday.
Ms. Burtis, back on March 12th of 2023, were you at 1054 North Cedar Street?
Yes, I was.
Is that in the city of Lansing, county of Ingham, state of Michigan?
Yes, it is.
And who was there with you?
Scott Patterson.
How do you know Mr. Patterson?
We met each other working last summer for field works, canvassing.
And did you live at that address?
I did on and off. I actually have a permanent address, but I stayed there a lot. We were dating
And how long had you been dating?
since September, October
Of what year?
of 2022.
And so what happened on March? Can you tell me about what happened on March 12th?
March 12th, I went over to his house late. It was actually on Saturday night. And we were hanging out, talking, drinking a little bit. And then he started getting angry, so I got up to leave. Sorry.
You know about what time it was? That
I think
you
1
got
a.m.
to- Okay.
So, I'm sorry, how could, you know, I'll continue. So I got up to leave and he was angry. And he hadn't hurt me before, but I dropped the charges.
And did at some point you lay down to take a
Yeah,
nap? Or,
I was laying down and then he was getting angry, so I got up to leave.
And why, do you remember why you were laying down?
I was tired.
Okay.
It was early in the morning.
And what happened while you were laying down?
Not on the, I was on the couch. I got up to leave. Then he grabbed me by the hair, swung me around. He then he slammed me on the ground, kneeled on my neck. I don't know how long it was. It was probably 10, 15, 20 minutes and proceeded to hit me.
And when you say he was kneeling on your neck, how was kneeling on your neck? Were you on your back?
Like the George Foreman thing. He was on my neck.
Were you laying on your back at the time?
No, I was on my side.
He was on your side, and he had a knee
on my neck.
Okay, on your neck. Was it on the right side or the left? Do you
It
remember?
was on the right side because I had rug burns on the left side of my face.
And so, do you know about how long he was kneeling on your neck?
I think about 20 minutes.
And did you have difficulty breathing at any point?
Yes, but I was screaming as well for help.
And did he just continuously have his knee there?
Yes.
Or did he stop and start?
No, he had it continuously.
And you said you were yelling for help.
Yes, I was yelling for, and I want to make this point if I can. I was yelling for help from the next door neighbor named Rudy. And I don't know what kind of language I can use, but he said, nobody can hear you. You bad words.
And did he say anything to you while he was doing this to you?
I have no idea. I was in panic.
Did
I
you-
think he was talking, but he was just mostly yelling and calling me names.
Did you lose consciousness?
Not that I know of.
Okay, what did it feel like when he had his knee on your neck?
I thought I was gonna die. It was so painful. I thought he was gonna break my neck. He was kneeling so hard.
Did he make any comments about killing you?
Yes. He said, you're gonna end up like one of those MSU students.
And was that referring to the shooting at Michigan State?
Yes. I'm assuming that.
And then you said he slammed your head onto the floor?
Yes.
How many times did you do that?
Just the one time.
Was that before or after he had knelt on your neck?
That was before, and then he kneeled on my neck.
May I approach, Your Honor? I'm showing the witness list been marked as people's 1 and 2. People's proposed 1 and 2. Just take a look at those really quick. Do you recognize those?
Yes. The officer took them the night or the morning it happened.
Do those depict your injuries and you on that day?
There's more. They didn't show up till later that day because I had bruises all over my thighs. I was not able to sleep, lay down for a week.
Do those ones depict
Yeah,
fairly
yes, they
accurately
do.
depict? Do they
Yes, they
fairly
do.
accurately depict you on that day?
Yes.
You know, the people who move for admission of people's proposed 1 and 2.
Any objection?
Without objection.
Admitted?
Permission to publish, Judge.
Yes.
And so you said you had some bruising on your neck.
My neck, my arms, my thighs, my hips, my back, my ribs. I had to sit up sleeping for a week. I couldn't lay on my back or either side.
Thank you, Your Honor. No further questions at this time.
Processing.
Morning.
Morning.
Oh. This was actually Mr. Patterson's permanent place of residence and not yours that you were talking about. Is that correct?
Correct.
And the incident that you were talking about, that happened at approximately 1 o'clock in the morning?
I
today?
believe so.
And what time had you arrived there?
Earlier in like 11 p.m. the night before.
Around a couple hours before that?
Yes.
Okay. And did you drive there? Did you walk there? How did you get there?
I drove there.
And you stated that you were drinking there during that night. Is that correct?
Yes.
Okay. What had you been drinking?
Actually, I hadn't been drinking there. I was drinking earlier, but
So you were drinking prior
usually
to,
we drink vodka.
so if I understand correctly, you were drinking prior to driving there, correct?
I don't remember.
Did you just say just a moment ago? That
I
you had-
believe I had a beer at home before I went over there.
So then to clarify, you were drinking before, prior to driving over there, correct? And you said you believed that you had a beer?
Yes.
Anything additional to that?
No. Do believe I had vodka at Scott's house, so
So once you arrived there and started drinking vodka, how much vodka had you consumed?
I do not know.
Were you doing shots or something else?
No, just like sipping a shot.
And if I understand your testimony correctly, you stated that he had his knee on your neck, is that right?
Correct.
And you believe that that went on for approximately 20 minutes, is that correct?
Correct. From my feeling, I don't know. I didn't like look at the clock or anything.
And at some point you spoke to the police about this matter, is that correct?
Correct.
Was that during that early morning or was that a different time?
That was early. I went home and I called the police immediately. And they came to my residence.
And you spoke to them about this?
Correct.
And you relayed to them what had occurred, is that correct?
Correct.
And did you tell the police that he had Mr. Patterson had his knee on your neck?
Yes.
Is it true that you told the police that he was squeezing your neck with his hands and you did not tell them that he used his knee?
I told them both.
And you had mentioned a neighbor earlier. You said name Rudy, is that correct?
Correct.
Is this an apartment complex that we're talking about?
No, they were homes, houses.
Like a townhomes?
No, house.
Okay. Was this a next door neighbor?
Correct.
Okay. You know Rudy's last name?
Actually, no, I do not.
But you've met or spoken with Rudy
Yes,
before?
many times. He lives one house north of 1054.
And so eventually at some point this incident stops, correct?
Well, when he said to me, nobody can hear you, you're gonna end up like one of
That
them
was not my
misuse
question.
students. Yeah, no, it didn't stop. I got enough strength because the adrenaline pumped when he said that. And I was able to finally push enough and then he tipped back. I kicked him and then I grabbed my purse and ran out.
And then did you drive back in your car? Or did you leave on foot?
I drove back in my car.
And you said you were screaming during this encounter, correct?
Yes, as much as I could, I was screaming for help.
To the best of your memory, no one responded to that scream. Is that correct?
Correct. Well, Scott
Did you go to the hospital after this?
No, I decided not to. The officer asked me if I wanted to and I declined.
Have a brief moment, Your Honor. And when you talked to the police that night, is it true that you told them you walked back to your place after this?
No.
Okay. All right, thank you. I have nothing further.
Can you clarify for me? You said you were on the ground and he had his knee on your neck.
Yes.
Okay, was there pressure being applied to your neck?
Yes.
Okay, did it obstruct your breathing at all?
Yes.
I'll read it back.
Thank you, Your Honor. You said that he had his hands on your neck too. At what point during this did he put his hands on you?
It was at first, when I was walking out, he grabbed me by my hair, and then he grabbed my neck, and then he slammed me on the ground.
So you were trying to leave
Yes.
and he was trying to prevent you from leaving?
Objection, lady.
Objection sustained.
Were you trying to leave?
Yes.
And you said he pulled you back in by your hair?
Yes.
And when he was choking you with his hands, did you lose the ability to breathe?
No, he didn't do it for long. He just grabbed me by the neck and then slammed my head on the ground and kneeled on my neck.
And who was the one that said no one can hear you?
Scott Patterson.
Is that person in this courtroom today?
Yes.
Can you please point to him and describe something he's wearing?
He's wearing a blue shirt.
Let the record reflect that the witness is ID the defendant.
Yeah, objections to
Without
ID.
Without objection.
So noted.
And you spoke to the officer and you said that you had declined medical. Why did you decline medical attention?
Cause it didn't, I think I was in shock at that point because nothing hurt until I went to bed and woke up and then everything.
No further questions at the time. Thank you.
May this witness be excused?
Yes, Your Honor.
Okay, thank you, Ms. Burtis. You may be excused. Just for the record, there is ma'am, there is a sequestration order, so that means that you can't speak to any other potential witnesses in this matter, okay, about your testimony.
Okay.
Thank you. You can be excused. Thank you. Are you calling any other witnesses?
Yes, Your Honor. At this time, the people will call Officer William Turbo.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury.
Yes.
Thank you, Officer. You can have a seat. Please state your first and last name, spell them both.
William Turbo, WILLIAM TERVO.
Officer Turbo, where do you work?
Lansing Police Department.
How long have you worked there?
Approximately 2 years.
In what capacity do you work?
Police officer.
Were you working on that capacity, in that capacity on 12th of March of 2023?
Yes.
And were you dispatched to 1054 North Cedar Street?
Yes.
Is that in the city of Lansing, County of Bingham, State of Michigan?
Yes.
Why were you dispatched there?
For a domestic assault.
And did you eventually make contact with anybody?
Yes.
Who did you make contact with?
The victim, getting her name escaping. Last name is Birdie. I probably mispronounced that.
Did you make contact with her at that Cedar Street or at a different location?
The address off of Woodruff Road.
And what was her demeanor like when you made contact with her?
She seemed kind of shaken up. Kind of like excited, but not happy. I guess you could say.
Did you observe any injuries on her when you saw her?
Yes, I did.
What did you observe?
She had red markings on her neck, and she also had pretty good bruise on her forehead, if I remember correctly.
And did you ask her what happened on that day?
Yes, I did.
Did she tell you what happened?
Yes.
Did she say who did that to her?
Yes.
Did you eventually come into contact with, who did she say did that?
Her ex-boyfriend, Scott Patterson.
And did you eventually come into contact with Scott Patterson?
Yes, I did.
Is he sitting in this courtroom today?
Yes, he is.
Can you point to him and describe something he's wearing?
He's sitting right there at the defense table wearing the blue and common jumpsuit.
Let the record reflect the witness and identify the defendant.
Any objection?
Just briefly forward here, Your Honor.
You may.
Morning, officer.
Morning.
Did you actually speak with Mr. Patterson that night?
No,
Are you familiar with Mr. Patterson?
I am.
And when is the last time you would have seen or encountered Mr. Patterson prior to this?
Prior to this incident, I've only encountered him 1 or 2 times. I couldn't tell you the exact date.
And did Ms. Burdays give you a full name or date of birth or anything?
Yes, she did.
Thank you. I have nothing further, Your Honor. No objection to ID for the purposes of this hearing.
Why are you familiar with him?
I've responded to that address for other calls for service.
Sounds good. Identification is noted. You can proceed.
Did you take Mr. Patterson to Sparrow?
Yes, I did.
And did he say anything or shout anything at Sparrow?
He shouted a lot of things.
Anything in reference to the victim?
He was repeatedly calling her vulgar names and saying that he was gonna go after her if he got out of jail.
What did she say that happened to her? What did she say he did?
She said she was sleeping on the couch. She woke up with him leaning over top of her, hands around her neck, choking her. Also had a knee on her neck. And he did this with squeeze, preventing her from being able to breathe, but then let her breathe. Just continually did that for what she approximated to be 10 minutes.
And was what she told you consistent with the injuries that you observed?
For the most part, yeah.
Thank you. No further questions this time.
Sam?
Thank you. Morning again, officer. So you're speaking about talking with Ms. Verdes and you described her demeanor as kind of excited, is that correct?
Yes,
And was this the first time you ever encountered Ms. Verdes?
I believe so, yeah.
And so then you can't tell us from any prior experience what her typical demeanor is like, is that correct?
That could be correct.
And based on your observations, did she appear to be under the influence of alcohol or any controlled substances when you were speaking?
She admitted to drinking.
And did you do any follow-ups and ask her how much over what period of time?
I asked her how much she had to drink.
Did she tell you?
I believe she told me 4 shots of vodka.
And you were speaking with her, this was at her place of residence, is that correct?
That is correct.
Okay. And after leaving Mr. Patterson's residence, is it true that she told you she walked back from his place to her place?
Yes.
And And you did not locate or speak with any other witnesses who claim to have witnessed this incident that Ms. Verdes was describing, is that correct?
She stated she was the only other person in the house other than Mr. Patterson.
Your Honor. Thank you, officer.
Can you redirect?
Yes, please, Your Honor. Officer, how many other times have you been called out to that residence?
Object to relevance.
I think you opened the door for it when you asked about his prior engagement with your client, so I'm gonna allow it.
I can't recall the exact number of times, but if I had to approximate, I'd say 3.
Some of those all for assault or domestic related incidents.
No.
Thank you. No further questions.
May this officer be excused?
Yes, Your Honor.
He may be excused. Any other witnesses?
No, thank you, Your Honor.
Is defense calling witnesses today?
We'll rely on the evidence presented, Your Honor. Thank you.
Argument.
Sorry, may I proceed? Thank you. Your Honor, we've heard from the victim, Ms. Burtis, who said that she was in a dating relationship with the defendant. They were at his house. She had had a drink or two. She was trying to leave at one point, and he grabbed her by the hair and pulled her back. He also grabbed her by the throat at the time and began to strangle her, Your Honor. She said that her breathing was not impaired during that time. However, he had took her and threw her to the floor, hitting her head on the floor. He put his knee on her neck. And at that point, her ability to breathe became impaired. She stated that she was screaming for help, and he responded with, "No one can hear you." With "no one can hear you," Your Honor. She testified that she did have bruising that was there present when officer showed up. He noticed red marks on her neck and a scratch on her forehead consistent with her head being slammed into the floor she testified to, and to a knee or something being around her neck at the time, Your Honor. She also said that the next day that those bruisings became more apparent. At this time, Your Honor, the people would also like to add an additional count 3 of unlawful imprisonment under MCL 750349B. Subsection B, secretly confine and knowingly restrain. And C, knowingly restrain to facilitate the commission of a felony, that felony being the great bodily harm by strangulation.
Any other argument?
She testified, as to that unlawful imprisonment, she testified that she was trying to leave and he grabbed her by the hair and pulled her back and then began to choke her. And that at another point during that time, he told her that nobody can hear you. So I'd ask that you bind over on all the counts and the added count 3 of unlawful imprisonment. Thank you.
Mr. Austin?
Thank you, Your Honor. Understanding, of course, that the burden of proof at this stage is probable cause, which is a relatively low burden. However, it is a burden that people must meet. The court is the sole determiner of credibility at this stage. And while I think it's arguable that a lot of testimony could be considered issues of fact for a circuit court jury to sift through, just some things I would point out, Your Honor, there does seem to be some inconsistencies with what Ms. Berdays testified to here today with what she apparently initially told the responding officer. The way the responding officer made it sound, Ms. Berdays was making it sound like this alleged assault occurred on the couch. Today she's saying that it occurred on the floor. She initially told the officer that it lasted for approximately 10 minutes. Today, she's telling us
You didn't testify to those things though today.
I'm sorry, Your Honor.
You didn't make any testimony about that today,
The officer, Your Honor?
about the time frame. He didn't testify.
I heard him say 10 minutes.
10 minutes, and she said she couldn't give an exact time because of her, she wasn't looking at a watch. So I don't know that that's an inconsistency.
Well, she said 10 to 15, 20 minutes in her testimony. And then the record can correct me if I'm wrong, but at least I thought on cross, she acknowledged it was around 20 minutes. That's all I'm saying.
Correct, but she also stated that she didn't look at her watch and that it felt like that to her.
I understand, Your
That's
Honor.
what so how is that an inconsistency?
Well, because again, Your Honor, all I'm saying is that she initially told the officer one thing. She said 10 minutes. I'm not trying to split hairs here, Your Honor, but that is what the responding officer testified to here today. And today she's giving us a broader time range, and then she's saying she's not sure. So I'm just merely saying that those two statements are not directly compatible or 100% consistent. That's all I'm saying.
Okay, your other statement as to what you believe is inconsistent is that she testified or she told the officer that it originally started on the sofa.
That is how I am interpreting his testimony, Your Honor.
Oh.
It is based on what she initially stated. She was making it sound like this entire encounter happened on the couch.
Oh.
I do know that I believe she said today that she drove back from Mr. Patterson's residence to her house. The responding officer confirmed that she told him that she walked back. So all I'm asking the court to do, Your Honor, is to evaluate all of this when determining credibility. I would oppose the bind over. I would specifically oppose the bind over on the request for an added count of unlawful imprisonment. I just don't believe that the testimony gives rise to that. I would ask the court to dismiss the matter at this time.
Okay, and as to her walking back or driving back, I think you questioned her about that. While she was under oath, she said that she didn't tell the officer that she walked back. You asked her if she told the officers if she walked back. She said she didn't tell them that.
She may have said that. What I'm saying is, Your Honor, the officer stated today that she told him that she walked back. Today, she's stated that she drove back.
But she said that on the record today under oath that she told the officer that at the time of the incident. She didn't change her testimony today. Nonetheless, any re-argument from the people?
Just briefly, Your Honor, I want to touch on the statements that Mr. Austin's characterizing as consistent. At the time that she was speaking with the officer, she was in fear. She was in fear for her life at that time. She had just been assaulted during that time. She testified that she felt like her neck was going to break at one point, Your Honor. And so I would just ask that Your Honor take that into account. Thank you.
Thank you. Today is the date, time that was set for a preliminary examination. The burden is on the prosecution at this time to establish there's sufficient probable cause that a crime was committed, insufficient probable cause to charge you with committing that crime. That's a flexible burden. It's based on the evidence presented today. It's not to be compared to the standard that they would have to face if this matter was to make it to a trial. At the time of trial, they need to prove each element beyond a reasonable doubt. This is a relatively low burden as indicated by your counsel, and it's more than mere suspicion that a crime was committed. I'm the sole and only determiner of credibility. And I'll make my ruling based on and considering the likelihood of the government's ability to establish guilt at the time of trial. In our complaint as filed, there is a count 1 of assault with intent to do great bodily harm, less than murder, or by strangulation. At the time of trial, per the Michigan Model Criminal Jury Instructions, the people would need to prove them beyond a reasonable doubt that first, the defendant tried to physically injure another person. Second, that at the time of the assault, the defendant had the ability to cause an injury or at least believe that he had the ability. And third, that the defendant intended to cause great bodily harm. Actual injury is not necessary, but if there was an injury, you may consider it as evidence in deciding whether the defendant intended to cause great bodily harm. Great bodily harm means any physical injury that could seriously harm the health or function of the body. The testimony of Ms. Bethany Burtis today was that she was in a dating relationship with the individual that she identified in court today as Scott Thomas Peterson. She stated that Patterson, thank you. She stated that at the date and time in question, that being March 12, 2023, at the area of 105 or North Cedar, City of Lansing, Ingham County, State of Michigan, that she was living there on and off with the defendant. They had been in a dating relationship since September, October 2022. They had been drinking prior to the incident. That they were talking, the defendant got upset, and that she was going to get up to leave. When she got up to leave, she testified that the defendant grabbed her by her hair, swung her around, slammed her, grabbed her neck, slammed her on the ground, and then he placed his knee on her neck. The court specifically inquired for a redirect by the prosecution whether or not the time of point in which the defendant's knee was allegedly on the victim's neck, if that restricted her breathing or if there was any pressure being applied. She testified that she thought her neck was going to break, that her airflow was restricted. Mr. Ring clarified on his redirect that even prior to her being slammed on the ground, that there was a point in which the defendant placed his hands around Ms. Burtis' neck, but it did not sound like that was for an extended period of time. Nonetheless, I think that the action of placing the knee around the neck and restricting with pressure and restricting her airflow would constitute a strangulation. The court is satisfied that there's sufficient probable cause as to count 1, assault with intent to do great bodily harm, less than murder, or by strangulation based on those facts that will be bound over to the circuit court. People are filed at count 2, domestic violence, which is a misdemeanor that will accompany count 1. People are adding to add a count 3 of unlawful imprisonment. At the time of trial, the people would need to prove, if this count is added, beyond a reasonable doubt, that the defendant knowingly restrained another person. Restrain means to forcibly restrict a person's movements or to forcibly confine the person so as to interfere with the person's liberty without the person's consent or without lawful authority. The restraint does not have to exist for any particular length of time and may be related or incidental to commission of other acts. Second, the defendant did so under one of the following circumstances. A, the person is restrained by means of a weapon or a dangerous instrument. B, the restrained person was secretly confined, which means to keep the confinement or location of the restrained person a secret. Or C, the person was restrained to facilitate the commission of another felony or to facilitate flight after commission of felony. The facts as we heard them today by the testimony of the alleged victim was that she was getting up to leave after the argument, at which point the defendant allegedly grabbed her by her hair, preventing her from leaving, swung her around, put her in the neck, put his knee on her neck, and that she was attempting to scream or yell for help. And he made some comments to the effect of no one was going to hear her and she was going to end up like one of those MSU students. The court is satisfied that there is sufficient facts pled today for an count of unlawful imprisonment for the purposes of commission of a felony or to facilitate right after the commission of felony, that being strangulation. And so that will be added and that will be bound over to the circuit court along with count 1 and 2. All three counts have a bind over date of April 12th. Mr. Patterson, you do not need to appear in court on April 12th. That's the date the circuit court gets filed from this court. Your next court date will be a pretrial in circuit court. Hopefully, Mr. Austin will be made aware of that date, okay? Is that a yes?
Yes, sir.
Bond was set at 75,000 cash surety with GPS tether and victim notification. Bond will continue. Any additional matters at this time?
Nothing on behalf of people. Thank you, Aaron.
We just briefly be heard on bond, if I may, Your Honor.
Okay.
Your Honor, I know there's been additional count added here today, but nonetheless, Your Honor, I am asking if the court would consider reducing Mr. Patterson's bond. It's currently set at 75,000, which is an amount that he could not or would not ever be able to afford to post. It is indicated that he has not posted it as of today. He has extremely limited income. As Ms. Verdes testified today, she does not reside with Mr. Patterson. So I think there's going to be adequate safeguards that would be able to be put in place to ensure all the safety occurs, as well as the community if he was released. Doing a search of his Michigan iChat, Your Honor, doesn't appear that I see any prior convictions for him. And I have Mr. Ring confirm that with a view of the CCH just earlier today. So it appears that he does not have any prior convictions that are showing up on his iChat, Your Honor. Danger of losing his home if he's not able to get out and tend to that soon. Given that, Your Honor, even with the additional count that was added today, I would ask the court to consider substantially reducing Mr. Patterson's bond.
Your Honor, I would like to just draw the court's attention to the testimony from Officer Turbo that he was at the Sparrow screaming very loudly that if he gets out of jail, he is going to get her. And also, I have informed Mr. Austin of some e-messages from the jail. There are currently upwards of 10 messages sent from him to her from the Ingham County Jail, Your Honor.
You mean in violation of his bond condition?
That is correct, Your Honor.
This should also be noted, that at least our records reflect that this is not the first time that there's been a domestic violence-related charge against Mr. Patterson with the same victim. And I believe at least on one of those occasions while he was out on bond on that pending matter, he allegedly picked up a PA-50 violation then by going to the same victim's house and assaulting him while out on bond. Bond, I believe, is appropriate under the circumstances. Anyone who is in the presence of the police and still threatening to cause harm to someone if released should be taken seriously as a threat. And so we have to take that threat seriously. With that being said, the bond will continue at 75,000 cash surety. Any additional matters for the record?
Nothing on behalf of people. Thank you, Your Honor.
With that, Your Honor, I have nothing further on behalf of Mr. Patterson.
Thank you. You're off the record.
I feel like my name is Judge.
You may, thank you. Not all our exams.
So for this morning. Somebody packed this Friday, full of things.
We're all booked up until June, so
Good.
we don't really have, we don't have much.
Eddie, I don't want to look at, I don't want to look at.
Well, look, make sure we got subpoenas going out
Oh, yeah.
and all the other good stuff.
I'm so angry. I'm so indescribably angry about it.
I mean, that saved you a 5-hour exam with Mr. Pfeiffer.